Hello and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by LiveLaw. I'm your host, Syed Amir Hussain, and I'm here to take you through the most significant updates from the week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelawmedia.in. In today's episode, we cover the Ranveer Allahabadia controversy, MP Iqra Choudhary's plea regarding mandir-masjid suits, Uttarakhand UCC, Chhattisgarh High Court's judgment on marital rape, and much more. First, we'll take a look at the top headlines from this week, and then we'll dive into the details of each case. So let's get started. Ranveer Allahabadia approaches Supreme Court against multiple FIRs over obscenity allegations. MP Iqra Choudhary approaches Supreme Court seeking strict implementation of Places of Worship Act. Directions issued against mob violence binding on all authorities. Supreme Court disposes of PIL to curb cow vigilantism. 2020 Bangalore riots. Supreme Court denies bail to accused. Directs Karnataka government to establish additional NIA court for UAPA offences. Supreme Court grants bail to SP leader Mohammad Azam Khan and his son in stolen machinery case. No guarantee you'll come back. Supreme Court rejects Indrani Mukerjea's plea to travel abroad. Expedites Sheena Bora murder case trial. Supreme Court summons Chief Secretaries of AP, Delhi and Jammu and Kashmir to explain failure to act against misleading medical ads. Lottery distributor not liable to pay service tax. Supreme Court rejects union's appeals. Those affected may approach us in case of any action by authorities. Uttarakhand High Court on pleas against Uniform Civil Code. Section 377 IPC. Unnatural sex by husband with wife without her consent is not an offence. Chhattisgarh High Court. This week, popular YouTuber Ranveer Allahabadia, also known as Beer Biceps, approached the Supreme Court seeking relief from multiple FIRs filed against him for allegedly obscene remarks made during a viral episode of India's Got Latent. The FIRs, registered by the Maharashtra and Assam police, follow public outrage over his comments, for which Allahabadia has since issued a public apology. His counsel, Dr. Abhinav Chandrachud, mentioned the Article 32 petition before Chief Justice Sanjeev Khanna. However, the Chief Justice noted that a hearing date was already assigned. When Chandrachud raised concerns about possible coercive action by the Assam police, CJI Khanna declined to comment, reiterating that he does not permit oral mentions. This week, Samajwadi Party MP Iqra Choudhary moved the Supreme Court, urging strict implementation of the Places of Worship Act 1991. In her writ petition, Choudhary argued that frequent suits and survey orders against mosques and dargahs without proper review heighten religious tensions and threaten India's secular fabric. The petition emphasized the doctrine of non-retrogression, citing the Babri Masjid judgment, asserting that the 1991 Act cannot be circumvented. Choudhary also warned against interpreting the Ancient Monuments Act 1958 to cover places of worship, which would violate rights under Articles 25, 26, and 29. Referring to the recent violence in Sambhal following a survey order against a 16th century mosque, she criticized ex parte interim orders from trial courts that permitted surveys without proper legal scrutiny. At the outset of this week's hearing, a bench led by Chief Justice Sanjeev Khanna expressed concern to senior advocate Kapil Sibbal, representing Iqra Choudhary, regarding the growing number of petitions on the same issue. Chief Justice Khanna orally remarked, "Why are so many new petitions being filed? We receive one petition every week." Nonetheless, the bench allowed the petition to be tagged with the batch of connected cases which either challenged the constitutionality of the Places of Worship Act or seek its enforcement. The batch is scheduled for hearing on Monday, February 17th. In a significant ruling this week, the Supreme Court disposed of a PIL seeking measures to curb car vigilante-related violence, stating that directions issued in the 2018 Tehseen Poonawala judgment are binding on all authorities. This PIL was filed by the National Federation of Indian Women, expressing concerns over an alarming rise of cases of mob lynching, particularly by Gauraksha groups. Although in the past, the court has pulled up state governments for their delayed response to this petition. This week, a bench of Justices B.R. Gavai and K. Vinod Chandran told Advocate Nizam Pasha, representing the Federation, that it could not micromanage compliance by all states sitting in Delhi and advised aggrieved persons to approach jurisdictional courts for redress. During the hearing, Solicitor General Tushar Mehta also assured the court that mob lynching is now a distinct offence under the new Bharatiya Nyaya Sanhita or the BNS, which has replaced the Indian Penal Code. The bench also noted that the prayers raised in the petition were omnibus in nature. On the petitioner's demand for a uniform minimum compensation for victims of mob lynching, the court rejected the plea, holding that compensation should be determined by case-to-case basis based on the severity of the injury. Additionally, regarding the petitioner's challenge to 13 state laws granting police-like powers to private individuals for cattle protection, the court directed aggrieved persons to challenge these laws before respective high courts. This week, the Supreme Court denied bail to Shabbar Khan, accused under the UAPA in connection with the 2020 Bengaluru riots, which erupted over a Facebook post allegedly containing derogatory remarks on Prophet Muhammad. The NIA has charged Khan and others reportedly linked to the Social Democratic Party of India, which was known as the political wing of the banned Popular Front of India, with conspiring to incite violence and taking over the KG Halli police station in Bangalore. The main thrust of Khan's plea, which was vehemently opposed by Additional Solicitor General S.V. Raju, was on the 4 years of incarceration and the absence of his name in the FIR. Although the court upheld the Karnataka High Court's decision denying him bail, importantly, it directed the Karnataka government and High Court to set up an additional NIA court within 3 months, citing the backlog of NIA cases and in an attempt to streamline. The Supreme Court, while declining to interfere, noted the significant pendency of cases before the NIA Special Court in Bengaluru, including 31 NIA cases, 53 sessions cases, and 2 criminal miscellaneous matters. Acknowledging such delay and noting the submissions by both the petitioner, represented by Senior Advocate P. Vishwanath Shetty, and Additional Solicitor General, the court directed compliance with the Karnataka High Court's order in the case of Shoaib Ali or Sajid Ali versus the state by Karnataka to establish special courts in Mysore, Belgavi, and Kalaburagi within 6 months. Additionally, the Registrar General of the Karnataka High Court, in coordination with the state government and the Chief Justice, was instructed to facilitate the establishment of an additional NIA court for UAPA cases within the next 3 months. This week, the Supreme Court granted bail to Samajwadi Party leader Muhammad Azam Khan and his son Muhammad Abdullah Azam Khan in the stolen machinery case. The duo had challenged an Allahabad High Court order that denied him bail, citing their criminal history and potential witness intimidation. The case involves allegations that during the Samajwadi Party's rule, cleaning machines purchased with public funds were secretly used at Johar University and later destroyed on Azam Khan's instructions to hide evidence. Investigators recovered the machine's remains in 2022, with university staff testifying to the discovery. Previously, the High Court had denied bail featuring intimidation of university staff who are key witnesses. However, a Supreme Court bench of Justices M.M. Sundaresh and Rajesh Bindal granted bail, considering their time already spent in custody and the completion of the charge sheet. The court, while granting liberty to the state to seek cancellation of bail if conditions are breached, highlighted that prolonged incarceration without trial should be avoided. The Supreme Court this week refused Indrani Mukherjee's plea to travel abroad while her trial in the Sheena Bora murder case is pending and directed that the trial be concluded within a year. A bench of Justices M.M. Sundaresh and Rajesh Bindal dismissed her appeal against the Bombay High Court's September 27, 2024 order, which denied her permission to travel abroad. The High Court had overturned a special court order that allowed her to visit Spain for paying property taxes, updating bank records, and revising her will to remove her ex-husband Peter Mukherjee. Mukherjee's counsel contended that the Supreme Court, when granting her bail in 2022 after 6.5 years in custody, had permitted her to travel abroad with CBI court's approval. The counsel stressed that her power of attorney holder in Spain could not complete the mandatory biometric registration required for executing the will. However, the bench remained unconvinced, with Justice Sundaresh stating, "There is no guarantee that you will come back," and directing that she may travel only after the trial concludes. In a limited relief, the bench ordered the trial's completion within 1 year. The Supreme Court this week summoned the Chief Secretaries of Andhra Pradesh, Delhi, and Jammu and Kashmir to appear virtually on March 7th. Directing them to explain their failure to act against misleading medical advertisement, as per court's previous orders. The order was passed during the hearing of a writ petition by the Indian Medical Association, which sought strict enforcement of Rule 170 of the Drugs and Cosmetic Rules 1945. A bench of Justices Abhay S. Oak and Ujjal Bhuyan expressed dissatisfaction with the state's compliance, stating that Andhra Pradesh, Delhi, and Jammu and Kashmir had not filed the required affidavits despite multiple orders. Justice Oak observed that summoning chief secretaries virtually was the most effective way to ensure compliance. The court had previously ordered all state and union territory governments to submit affidavits regarding detailed action taken since 2018 against misleading advertisements under the Drugs and Magic Remedies Objectionable Advertisement Act of 1954 and the Drugs and Cosmetics Act of 1945, along with the Consumer Protection Act of 2019. Despite warnings of contempt proceedings, the three states failed to comply. The court granted them time until the end of the month to submit their responses and warned that if the non-compliance persisted, further action, including personal appearances, might be required. The matter will be reviewed on March 7th. This week, the Supreme Court ruled that lottery distributors are not liable to pay service tax, dismissing the union government's appeals against the Sikkim High Court's judgment. The High Court had declared Clause ZZZN of the Section 65, Clause 105 of the Finance Act 1994 as inserted by the 2010 amendment unconstitutional. This clause sought to tax services related to promoting and organizing lotteries. The case involved private companies selling lottery tickets for the Sikkim government. They challenged the clause, arguing that their activities fell under betting and gambling in entry 62 of the state list, which only state legislatures can tax. The High Court agreed, ruling that the sale of lottery tickets was not a taxable service and struck down the provision. A bench of Justices B.V. Nagaratna and N.K. Singh upheld the High Court's view that the relationship between lottery distributors and the Sikkim government was that of principal to principal, not agent to principal. Therefore, no service was rendered to the state, and service tax was not applicable. Justice Nagaratna clarified that since there was no agency, There was no taxable service under the Finance Act. The distributors will, however, continue to pay state gambling taxes under Entry 62. In a significant development this week, the Uttarakhand High Court provided temporary relief to individuals affected by the state's recently implemented Uniform Civil Code, or the UCC. The bench of Chief Justice G. Narendra and Justice Alok Mehra, while hearing 3 petitions challenging the UCC, stated that anyone facing action under the code could approach the court for relief. Senior advocate Kapil Sibbal, representing one of the petitioners, sought a stay on the UCC, arguing that it violated fundamental rights under Articles 21 and 25 and questioned the state's competence to enact such a law, citing Entry 5 of the concurrent list. The bench, noting that notices had already been issued to the state in 2 other petitions, scheduled the hearing on the stay application for April 1st. The court clarified that any individual impacted by the UCC could approach the bench for urgent relief. Notably, the UCC implemented on January 27th makes Uttarakhand the first state in India to enact such a law. The code mandates registration of live-in relationships, introduces conditions for contract marriages, and bans practices such as halal, iddat, and polygamy, while granting equal inheritance rights to men and women. It applies to Uttarakhand residents even if they live outside the state, but excludes scheduled tribes. 2 public interest litigations pending before the High Court separately challenged the UCC's provisions on live-in relationships, marriage, and divorce, claiming they infringe upon constitutional rights. In a judgment that has reignited the debate over marital rape, the Chhattisgarh High Court has held that a husband cannot be prosecuted under Section 376 rape or Section 377 unnatural offences of the Indian Penal Code, or IPC, for engaging in any form of sexual intercourse, including unnatural sex, with his adult wife, even without her consent. Justice Narendra Kumar Vyas, sitting as a single bench, observed that under Exception 2 to Section 375 IPC, sexual acts by a husband with his wife, provided she is not under 15 years of age, do not constitute rape. The court further ruled that this protection extends to acts categorized as unnatural under Section 377 IPC. The case stemmed from a tragic incident on December 11, 2017, where the appellant, the husband of the deceased victim, was accused of committing unnatural sex against his wife's will, causing her severe injuries. The victim's dying declaration, recorded by an executive magistrate, stated that she became critically ill following her husband's actions. A subsequent post-mortem revealed rectal perforations and peritonitis as the cause of death. The trial court had convicted the husband under Sections 377, 376 and 304 of IPC, sentencing him to 10 years of rigorous imprisonment. However, on appeal, the High Court has overturned the conviction, holding that since the legal definition of rape excludes sexual acts between spouses where the wife is above 15 years, no offense under Section 377 could be made out either. However, the court did not disturb the trial court's findings regarding culpable homicide under Section 304. And that's a wrap for this week's Legal Roundup. Before we bid adieu, the entire LiveLaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. Here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues. Make sure you're subscribed to our YouTube channel for more insightful content. Drop your valuable thoughts and feedbacks in the comment section below. And hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for in-depth reports and analysis. Not only this, but the LiveLaw channel offers memberships for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in the comment section and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I am your host Syed Amir Hussain, and it's been a pleasure bringing you this week's legal news roundup. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.